Good afternoon, everybody. I think we're just into the afternoon, so welcome to our webinar. We're looking at quite a niche topic today. We're looking at essentially data export. I'm Joanne Bone, and for those of you who don't know me, I'm a partner in our commercial team, and I specialise in data protection. So this is definitely my sweet spot. So in terms of what we're going to cover today, on the next slide, you'll see that we've got a sort of list of things that we're going to have a look at. So we're going to have a look at essentially the UK's data adequacy decision that's come out of the EU recently, the new EU standard contractual clauses, the new recommendations that have come out of the European Data Protection Board, which are allied to the new standard contractual clauses, where things stand from a Privacy Shield point of view in terms of are we close to Privacy Shield 2, and essentially what the UK's approach to data export will be now we're sort of in the post-Brexit period. So in terms of a couple of housekeeping points, if you could post any questions that you've got in the Q&A, and ideally if you could leave your email address, and then if we don't get a chance to answer the questions, we can come back and we can sort of contact you after that. So the first point I think to make in relation to the contents list in terms of the things that we're going to be having a look at today is that because we're in a post-Brexit era, that there will be some divergence between the UK and the EU. And some of the things that have come out are UK focused, some of the things that have come out are EU focused. And so essentially what we're grappling with are two versions of GDPR. And I appreciate that a number of you will know this, but I thought it would be useful to have a quick recap, and I will be going through recapping and setting the scene before launching into some of these things when we get into the meat of this. But essentially, as I say, there are two versions of GDPR that are kicking around at the moment. So there's the EU GDPR, and that's obviously the original version of GDPR. It applies to people who are established in EEA, so EU member states plus a few more. And post-Brexit, GDPR did not go away, or well, it's not gone away yet, and more of that later. It does still exist, and there is a UK version of GDPR, which applies to businesses established in the UK. Both of UK GDPR and EU GDPR have got extraterritorial effect, and so it may well be that even if you're just based in the UK, you are actually also caught by EU GDPR, so that some of the provisions that arise from EU GDPR may actually apply to you, even if you are just based in the UK. And I will try and remember as we're going through to signpost whether it's a UK provision or whether it's an EU provision. If anybody's wondering in terms of when the extraterritorial effect will kick in, both regimes have got extraterritorial effect. So you are caught if you're established in either the EU, EEA or UK. In terms of if you're in the UK, you're caught by UK GDPR. If you're established in the EU or EEA, you're caught by EU GDPR. But in addition to that, if, for example, you're based in the UK, but you are offering goods or services to individuals who are based in the EEA, or you are monitoring data subject behaviour, then you will be caught by the extraterritorial effect of EU GDPR and caught by it, and vice versa. If you're in, say, France, established in France, and you are then selling to people in the UK, or you're monitoring data subject behaviour. So it's worth bearing that in mind. And as I say, we do sort of flip-flop between the two in terms of, is it a UK issue, is it an EU issue, or is it an issue for sort of people in both that could potentially caught by both regimes. So if we can move on, and I apologise if I sound like Chris Whitty, but in order to drive this, I have got somebody else that is going to be sort of moving forward with the slides. So yeah, it's not a COVID briefing, so don't worry. So in terms of the first thing we're going to have a look at is the export issues relating to the export of personal data from the EU outside the EEA, actually outside the EEA, and also from the UK outside the UK, and both EU GDPR and UK GDPR have got the same controls on those things. So under both regimes, if you are sending personal data from the UK outside the UK, or if you are sending personal data caught by EU GDPR outside the EEA, then you have to jump through some hoops to be able to do that. So traditionally, the issues that have arisen have related to places like America, India, and now from an EU perspective, there's also the UK on the list because we are not in the EEA, so we are what's known as a third country. So in terms of what do you do, what are these hoops that you have to jump through? So by way of a quick recap, and these are on the slide in terms of if we could move on, you'll see that on the slide we have got 3 lozenges, and they are in order of where you should go first. So you should start with Article 45. So you should consider whether or not the country that you're wanting to send the personal data to has got a finding of adequacy. And there are a list of countries that the EU Commission has granted adequacy to, and from a UK perspective, we have agreed that all of those countries will also get adequacy from a UK perspective. So if you are sending personal data to a country on that list, then you are within Article 45 and you are okay. Quick word of warning is that it's not necessarily the finding of adequacy isn't in relation to necessarily all sectors, in that it might just apply to the commercial transfer of personal data, not a public sector transfer. So you do need to have a look at the country that you're interested in and also make sure whether there's any other sort of restrictions on what you're planning on doing. But certainly adequacy makes life easier, and it is the first thing you should have a look at. In terms of signposting where we are with adequacy, South Korea is currently going down the adequacy route with the Commission, so fingers crossed that will be an additional country we can add to the adequacy list in the relatively near future, although adequacy is not that quick, so I'm not sure how near future it will be. If the country that you're wanting to send the personal data to doesn't have a finding of adequacy, then you're then thrown into Article 46, and you've got to see whether or not there's another safeguard that might help you export the personal data in terms of that's an alternative hoop to jump through. And you'll see from the pink lozenge on the slide that essentially what we're talking about are standard contractual clauses, binding corporate rules, and a couple of others that aren't yet available, which is a certification scheme and a code of conduct. Certainly standard contractual clauses are by far and away the most popular way of exporting personal data if there isn't an adequacy decision. And I think IAPP did a survey, and I think 88% of data export is done on the basis of standard contractual clauses. So standard contractual clauses are really, really important, and this is why there's been so much focus recently in the new versions that have been issued by the Commission, and this is why we're talking about it today. If you can't send it to a country where there's adequacy and you haven't put in place standard contractual clauses, there is a third alternative, which are derogations. But the thing to bear in mind with derogations, and this is something that we see a lot, is that there is a misconception around them. The derogations are very much a last resort. You shouldn't use it for ongoing continued data export. They are exceptions, they are not the rule. So if you are going to be using, essentially exporting the personal data on a regular basis, do not start with Article 49. That is really not what they're there for. It is one-off or occasional transfers you should be looking to those for. So that sort of sets the scene as to having to jump through additional hoops if personal data is going outside the EEA or the UK. So as I sort of mentioned when we were talking about third countries and countries outside the EEA, obviously following Brexit, the UK became a third country. And so there's been a lot of discussion as to what would that mean in terms of personal data coming from the EEA to the UK. So moving on, what I'm going to have a look at is the recent decision by the Commission to give the UK adequacy. So essentially to put the UK in the first box in terms of the lozenges we were looking at, so that the UK has an adequacy decision. And you'll see on the next slide that the Commission gave the UK adequacy on the 28th of June. And for those of you who have been following whether or not the UK would get adequacy and how you would export personal data from the EEA to the UK post-Brexit. You'll remember that at Christmas, cutting it quite fine, I think it was Christmas Eve, that the TCA, the Trade and Cooperation Agreement, was agreed, and one of the elements of the TCA was personal data, and it allowed for what they call a bridging period for personal data to be able to be sent from the EEA to the UK until the 30th of June 2021 as a long stop. You'll see from the date on which we were actually granted adequacy that there were 2 days to spare. Certainly nothing like cutting it fine, that's for sure. It's not like businesses had to plan or anything. But anyway, so we did get adequacy. And so the panic in terms of would the bridge end, what would happen at the end of the bridging period having ended if we didn't get adequacy, and what would happen in terms of what would businesses have to do. Unfortunately, that issue didn't arise. But it's not all quite as straightforward as you might think. So we have got adequacy, but, and there are some buts that surround it, and I think they are things that people need to think about. And it is quite important because there is a lot of data that comes from the EEA to the UK. There's quite a lot of personal data that moves around from a group perspective, and we have a lot of clients who, for example, have got centralised services in the UK, and personal data is coming from the EEA to the UK. So it is very important. So in terms of what's in the adequacy decision, well, the first point to note is that essentially it's subject to a sunset clause. None of the other adequacy decisions have got this sunset clause, but the UK adequacy decision will end unless it's renewed at the end of 4 years. And I think that is driven by a concern that whilst UK GDPR and EU GDPR align at the moment, that might not be the case going forward. I think that's definitely recognised by the Commission, because in addition to the 4-year review period, there is also an ability for the Commission to review the position and change what's been decided from an adequacy point of view if they have what they call a problematic divergence. So clearly there is concern within the Commission that UK law may change from a data protection point of view. And to be fair, that probably is something that they do need to consider, not least, and I'm not going to talk about this in a huge amount of detail, but there has been a think tank that the government put together to look at how the UK regulates personal data and should we stick with GDPR, which is the Task Force on Innovation, Growth and Regulatory Reform, which is either Tiger or Tigger, whichever one you would prefer. I quite like Tigger. That think tank was led by Ian Duncan Smith, and it has suggested alternatives to GDPR. It suggested that we might replace GDPR with a UK framework for citizens' data rights, in terms of it would make life easier for business because GDPR is prescriptive, inflexible and onerous is the view of the task force. Now you can understand if that sort of thing is being issued by the UK government, why the Commission might be a bit nervous and essentially be concerned that there would be problematic divergence either during the 4-year period, or that there may be incremental problematic divergence that needs to be looked at in the whole at the end of the 4-year period. So that sort of explains why we have got a slightly odd version of adequacy for the UK. I think the other thing that's worth bearing in mind is what it doesn't cover, and certainly it is probably worth flagging that it covers only essentially transfers from the EEA to the UK. There is a bit of a misconception that it means that the UK is adequate for lots of countries and anybody can choose to send their data to us and it'll all be fine. That's not the case. It also doesn't cover transfer from the UK to the EEA. An adequacy decision is not currently sort of needed as such, because the government have said for the time being that's perfectly fine. So there isn't a formal adequacy decision issued by the ICO on that. So it is very limited in scope from a geographical point of view. The other thing to bear in mind is it's limited in scope in terms of there is a carve out for immigration data. And immigration data has been at the forefront of things recently. in that certainly the European Parliament didn't like the draft adequacy decision. They had a lot of concerns about UK data protection laws, notwithstanding the fact that obviously we've had GDPR for quite a long time. And one of the things they were concerned about is one of the exemptions in Schedule 2 to the Data Protection Act 2018. Now, the Data Protection Act 2018, that sits alongside essentially GDPR, and that's where you'll find all the exemptions. There aren't many exemptions in GDPR, they're all tucked away in the Data Protection Act from a UK perspective anyway. And there is a provision in Schedule 2 that you cannot have access to personal data in the context of immigration where it would prejudice the maintenance of effective immigration control, I think is the wording. And certainly the European Parliament didn't like that. And there has actually also been a Court of Appeal case recently in which that exemption was regarded as not being a valid exemption. And so it is something that's under consideration anyway, as a result of the Court of Appeal, and certainly the European Parliament didn't like it. So that is carved out from the adequacy decision. So immigration data is not covered by this adequacy decision. I think the other thing that there was some concern about from an adequacy point of view is onward transfer in terms of using the UK as a stepping stone, and that is something that again is expressly stated in the adequacy decision as something that will be kept under review by the Commission in terms of whether or not the adequacy decision should continue. And again, you can understand why there is a concern around that, and we'll have a look at that later in terms of what the UK has said in terms of its own data export policy going forward. Now, I've put on the bottom of the slide as to whether or not the UK adequacy decision will trigger Schrems 3, and we'll be talking about Schrems 1 and 2 briefly in a minute, and those of you who have any involvement with data protection, I'm sure that you've all heard of Mr. Schrems. And certainly he has form for invalidating adequacy decisions on the basis that essentially there are 2 EU or EEA US adequacy decisions that he's managed to get rid of in terms of both Safe Harbour and Privacy Shield. So it'll be interesting to see whether, in view of the issues around one of the concerns that's also been raised in relation to the UK adequacy decision is the access by the security services and the various other things, as to whether or not it was proper for the Commission to give the UK adequacy. So I suspect if it's not Schrems 3, it will be some privacy organisation that will be gunning for the UK adequacy decision, but we'll have to just wait and see what happens. So in terms of export from the EEA to the UK, that has now been sorted, at least in the short term. So I'm now going to move on in terms of having a look at the new standard contractual clauses that the Commission has issued and the European Data Protection Board guidance. Now, on the next slide, I'm going to recap on Schrems because essentially a lot of this has come from Schrems. So the new standard contractual clauses, were always going to be needed post GDPR. So the old standard contractual clauses, essentially they had a lot of language in that was derived from the directive because they were issued under the directive, and the directive is the precursor, as you will know, to GDPR. So they always needed to be updated, but this was given impetus by various pieces of litigation. Schrems 1 is the older version. I'll only provide that by way of background, in that Max Schrems was an Austrian law student. I believe he was doing some time studying in America, made a subject access request, found out how much personal data was held by Facebook in the States, and was concerned about access by the security services in the States on a surveillance basis. So he argued that the then US version of adequacy, Safe Harbour, essentially it was a limited form of adequacy, was invalid because it couldn't control the security services properly. It didn't control the security services properly, and he got that invalidated. Now, having done that, moving on to the next slide, he decided to have a crack at the standard contractual clauses. Now, his view was which logically is correct, that the standard contractual clauses, they are in place between the organisation that is exporting the personal data and the organisation that is importing the personal data. The public authorities in the country where the data is going to are not party to the contract, and therefore the contract can't tie their hands, and therefore the contract can't stop the security services accessing personal data that's been transferred pursuant to the contracts. So he complained about this, and this became Schrems 2. Now, the standard contractual clauses were the main focus of Schrems 2, but by it being introduced as part of the court case, Privacy Shield, which is the subsequent version of limited adequacy to the US, which replaced Safe Harbour, that was also brought into the mix. And the two things that came out of Schrems 2 is, one, Privacy Shield had to go. So any form of adequacy between the EEA and the US is currently gone, and that's under negotiation, which we'll have a look at later in terms of what the replacement might be. But the other thing, and I think this is the thing that's relevant for the standard contractual clauses, is the standard contractual clauses themselves were valid. The thing is, the court said, is that taking on board Mr. Schrems' point that you can't bind the security services by standard contractual clauses, is that you have to look at the regime, the legal regime of the country that you're sending the personal data to, because essentially, if you're sending it to a country where the laws around access by security services will undermine the standard contractual clauses, essentially you're sort of making them not be as effective as they should be. So what the decision of the court was, is that the standard contractual clauses, you have to do an analysis of the jurisdiction and the laws in the jurisdiction in terms of right of access by public authorities and also right of redress by the individuals whose personal data is going. And you have to make a decision in terms of, do those laws undermine the standard contractual clauses or do they help the standard contractual clauses? So essentially the sort of buzz idea was that essentially the protections from GDPR must travel with the personal data, so that just by sending it to America, for example, you can't just sign on the dotted line, put the standard contractual clauses in a drawer and then not care whether or not US law will sort of cut across them. So that's the sort of background to Schrems, and that's why, even though the standard contractual clauses were up for review because GDPR had come in, they were given extra impetus by that court decision. So now moving on in terms of the standard contractual clauses, and the crux of what's come out recently is that the long-awaited standard contractual clauses essentially has come out on the 4th of June, and there are some very important aspects to it that need to be thought about. There was originally a version that was issued in November 2020, but there are changes between the two, so it is worth don't just go with the November version. And for anybody that's interested, there are kicking around on the web some interesting red line versions of the old draft version of the standard contractual clauses and the new version of the standard contractual clauses. I think back to my point in terms of identifying whether or not this is an EU thing or whether it's a UK thing, and they are issued by the Commission and they relate to the export of personal data outside the EEA pursuant to EU GDPR. So they do not apply to personal data that is protected by UK GDPR. So what is in the standard contractual clauses? I think the first point to make clear is the issue that I was raising in terms of the fact that they did need to be put in place anyway because of GDPR, is that a lot of the language has changed. So a lot of the language now is GDPR type language, and if you read them you'll see there's some very familiar terminology that's used in them that you'll see in the obligations under GDPR. The other thing that they do, which is really helpful, is that there is a recognition, and certainly in the implementing decision, this is definitely recognised, is that data flows have become a lot more complex. So when the first set of standard contractual clauses were issued, and way back, data flows were a lot less complicated than there are now. There are a lot more international data flows, but not only are there a lot more international data flows, but there are a lot more sort of entities in the chain. So that quite often you don't just have a simple controller and then a processor. You could have a controller, processor, subprocessor, and you've got a lot of people that are in the chain. And people were struggling with the existing standard contractual clauses to make them fit all of the situations that they were encountering, because there were only two versions. So there was a version that dealt with controller to controller transfers, and there was a version that dealt with controller to processor versions. And the thing that people were struggling with was that you were not meant to change the text of them, and they didn't apply. So that if essentially you were a processor, for example, you were a processor based in France, and you were then sending personal data to a subprocessor, say based in the US, what were you meant to do in terms of how would you get that data there? So there are new versions. So there are 4, which you will see on the slide. So we have got the 2 traditional ones. We've got controller, we've got controller processor. We've now got processor to their processors, or subprocessors as they're generally regarded. And we also have a 4th one, which is a processor to controller. And what that's for example, is if you have a controller that's based in the US and they want a processor in France to do something with their personal data. So the EU GDPR doesn't interfere with data coming from the US to France, but what it does intervene in is the personal data going back from the processor in France to the US, because processors are caught by the restrictions on export in the same way as controllers. And there was concern that obviously the clauses didn't do that, and it was becoming more common that sort of thing was happening, and it was causing people problems. So there are these different versions of the clauses. Now the thing to bear in mind is that they have been put into a modular version. Now previously you had the controller clauses, you had the controller processor clauses, and they were all nicely printed out in terms of these are the controller ones, and these are the controller processor ones, so it was dead easy to work out what you needed. Under the modular versions, there are some clauses that apply to everybody. There are some clauses where you have to pick the right bit of the clause that applies, and it is headed up. And I think the other thing to bear in mind as well, which is an added complication, in the processor to controller side of things, is that some of the clauses are only applicable where you have got a processor to controller transfer, and the processor is not just sending back to the original controller the original personal data, so that the processor has added to it, for example. So you do need to read quite carefully the titles of the clauses so that you can essentially in titles of the clauses and the sort of subheadings within the clauses, so that you can essentially build your own version of the standard contractual clauses that you need. So it does need a bit of thought in terms of picking out the right part of the clauses. The other point is that they can be used for multiple parties, and also there is a docking clause. Quite often, and I see it quite a bit in a group context, that you'll have a new group company that will join the group, and they want to add them to any transfer arrangements via standard contractual clauses. And certainly there is an ability now to use the docking clause. Although, to be fair, whilst the docking clause is there, it's not entirely clear in terms of how that's going to work in practice, and whether essentially you can have counterpart documents or whether you've got to have one single document. But I do think a lot of this stuff will come out in the wash, not least because GDPR has been in place for 3 years now, and that's not entirely clear yet. So I'm sure that there's a lot of things that we'll realise that aren't entirely clear in these standard contractual clauses and EDPB guidance that we'll look at in a minute, and that'll all sort of come out in the wash. The other thing which is important in these standard contractual clauses is that they address the Schrems II decision. So they address the issue of making sure that the parties have to check what the law of the country where the data is being imported into is, and whether or not that will undermine the protections from the standard contractual clauses. So there is an obligation on both parties, and certainly I have seen arguments when the Schrems II decision and the old version of the European Data Protection Board, sorry, I shouldn't call it guidance, it's recommendations. Scratch any time I've referenced it as guidance, it is recommendations, and that is important, and I will explain why that's important in a minute. Sorry, it's old habits. So those recommendations, essentially there was an argument that it was just a job for either the exporter or it was just a job for the importer, and that one party could wash their hands of it. One of the things that standard contractual clauses do is make it very clear that it's the job of both of the parties to sort this issue out, not least because the importer is likely to have a better view than the exporter in some respects in terms of what happens on the ground in the jurisdiction. And certainly what is suggested and has been suggested for a while from the European Data Protection Board recommendations, which work in conjunction with these standard contractual clauses, is when you're doing the assessment of the country to make sure that the SCCs will work, is one, it has to be done in writing. I mean, that shouldn't be news to anybody, because essentially from an accountability point of view under GDPR, everything, any decision, and particularly any risk decisions made from a data protection point of view should be done in writing. The other thing that's come out of this is a transfer impact assessment. So we now have DPIAs, which are data protection impact assessments, LIAs, legitimate impact assessments, and now we've got transfer impact assessments. So who's to say that lawyers don't like a good acronym? So when you are putting together your TIA, it does give you an idea of the sorts of things that you need to take into consideration, and similarly that is something that the European Data Protection Board recommendations do, and that's what we'll have a look at in a minute. So moving on, another key issue that needs to be thought about is that in the version of the standard contractual clauses which affect processors, so essentially if it's the controller processor one, for example, there are detailed provisions relating to the processor relationship. Now, anybody that's familiar with GDPR will know that leaving export on one side, any processor that you engage, so anyone you engage to carry out services in relation to your personal data, for example, an outsourced HR arrangement or data crunching, you do need some protections in place. They are mandatory under Article 28 of GDPR, and you need some processor clauses in place. Now, they did used to be required under the Data Protection Act 1998, which was the UK precursor to GDPR, but they did change from a GDPR point of view. They became a lot longer. And certainly a lot of people did a lot of what they call repapering, ready for GDPR, and put in place some process clauses. Now, the standard contractual clauses have got those processor clauses within them now, which raises an interesting question in terms of if you had a processor that you weren't exporting to, and you already had some Article 28 clauses in place with them, if when you move to the standard contractual clauses, and we'll have a look at the timeline in a minute in terms of when can you use them and when do you have to use them, then do you have to move to the version of the processor clauses in the standard contractual clauses? I think you probably do. And the reason for that, and I'm sort of a little bit cagey, because I think that's what the upshot of Clause 2 is, but there is some discussion going around in relation to that. So what Clause 2 basically says is that you have to, as was the case before, if you want to align protections in the standard contractual clauses, implement them in a form where you don't change the standard contractual clauses. You can add to them, you can put stuff around them as long as it doesn't undercut them, but the content of the standard contractual clauses themselves can't be changed. And so if those processor clauses are in there, in order to get the protection of the SCCs, I think you have to go with that version. Now, certainly, I think the point to bear in mind is that you may want additional stuff in there to supplement the SCC's version of the Article 28 processor clauses. So, for example, you might want a bit more detail or process around what you expect the processors to do if they've got a data breach or anything of that nature. And I think you can certainly add to them, but I think that is something that will be worth bearing in mind. Now, as I say, and I said at the outset, I am talking about EU GDPR, so data that is caught by EU GDPR. I'm not talking about UK GDPR data. Also, there is a hierarchy clause that even if you don't, say, for example, put in place a whole new agreement and you leave your existing processor clauses in place, the SCCs will override. I think it's also worth bearing in mind, which we don't really have time to cover today, that in addition to the new versions of the standard contractual clauses that have been issued by the Commission on the same day, there was a version of the new standard processor clauses issued by the Commission. And those processor clauses are essentially the Article 28 clauses, but they are not mandatory. They relate to, it's under EU GDPR, so back to that distinction, and they are not mandatory. You can pick to use them or you can choose not to use them. I think the point is, though, if they become the standard from a market point of view, then obviously there'll be impetus to use them. One of the questions that we have been asked is to what extent can the SCCs be changed as a result of negotiation? If you want to rely on them and get the protection from them, you can't change them. You can add to them, but that can't change the content of the SCCs, and certainly that's always has been the case. And you might not like some of the provisions, and commercially you might not be very happy with them. You might not be very happy with the liability provisions, which I'll have a look at in a minute, but you cannot get rid of them, because if you get rid of them, then they are no longer the standard contractual clauses, and you can't use them or you can't rely on them as being a way to export personal data in a manner that has been approved by the Commission. So you need to be really, really careful. So you can tinker around the edge, you can add stuff, you can fill in the schedules and the annexes, but you can't delete stuff and change it. So moving on to the next slide, apologies, you'll see that I've put a timeline because it's not entirely straightforward about how these standard contractual clauses, when they come into force, when you have to use them, when can you use them, what's the long stop date. So as you'll see there, they were published on the 7th of June, officially published on the 7th of June. They could be used from the 27th of June 2021. So we're now past the date on which you can choose to use them. You don't have to use them, however, and you can continue to use the old versions of the standard contractual clauses until the 27th of September 2021, because that's a transition period. So even for new arrangements, you can use the old SCCs if you want to until the 27th of September. Now, at the 27th of September, you've got to use the new SCCs for any new arrangements, or if you are changing the way in which the export is happening or the processing that is subject to the export. And then you've essentially got a long stop date of the 27th of December 2022. So until 27th December 2022, existing arrangements can stay on the old standard contractual clauses, but by 27th December 2022, if you are talking about data that is subject to EU GDPR, you have got to have migrated onto the new versions of the standard contractual clauses. So I think it is worth factoring that in in terms of making sure that you plan for this repapering exercise, because you're going to have to work out which version of the standard contractual clauses you need. You've got to fill in the commercial aspects that and the context that needs to sit in the annexes. And obviously you've then got to send them out to whoever you need to sign them with, and you've got to agree the terms, which brings you back to the point that somebody asked a minute or two ago in terms of, well, can you change them? And I think that they will be subject to some discussion when you're telling people that they can't be changed, particularly people who are not particularly familiar with EU GDPR. And we do see sometimes arguments with American companies, for example, who regularly don't want to accept the old version of standard contractual clauses. So I can't imagine they'll be that much keener on the new version of standard contractual clauses without change. So moving on, in terms of, there is something that I am just flagging here, and I don't think this issue has been resolved yet, and I think it's something to just be alive to, and I'd be interested in anyone else's views in relation to this, is that, as I was mentioning earlier, it is possible that you could have an entity that is based outside the EEA, but is caught by EU GDPR by virtue of its extraterritorial effect. And there is a statement to say that these standard contractual clauses are not for use where you are transferring personal data to somebody outside the EEA, but who is caught by the extraterritorial effect of EU GDPR. Now, I was on a webinar in which a rapporteur from the EDPB was asked this question in terms of how does this work, and the answer that was given is that the extraterritorial effect in Article 3 of GDPR and Chapter 5 relating to export is something that they are thinking about and are going to issue guidance in relation to, which is great, apart from at the moment, I'm not sure what the position is in relation to that. So I think it's something to just be alive to, and I'll certainly be doing further digging and trying to monitor as to any thought leadership in relation to that aspect of it. The other point to bear in mind on the standard contractual clauses is the liability point. The liability provisions, they are one of the things that are caught by the work out which type of arrangement you've got, because you've got to put in the right liability clauses depending on the arrangement. Is it controller or is it controller processor? One thing to bear in mind is that there is a specific provision in the standard contractual clauses giving data subjects direct rights against the parties to the standard contractual clauses, or certainly most of them, not the ones that apply just between the two parties, but those that affect the data subject. So that needs to be borne in mind, and that there are different provisions relating to the liability between the two parties, the exporter and the importer, depending on what type of relationship it is. Obviously, one of the perennial questions that we have in relation to both processor clauses under Article 28 and standard contractual clauses in terms of export is the ability for the parties to limit liability between them. And I think that is something that certainly from the standard contractual clauses is looking more difficult, and it will certainly be interesting to see how that pans out. Because there is a provision to say that if one party essentially has to pay out to a data subject as a result of something the other party has done, then they can recover it from that other party, which is not sounding to me like the ability to limit your liability. But again, I think this is something that needs a bit more ironing out and thought. So it is a case of let's watch this space in terms of where that ends up. Moving on to the next slide, in terms of, well, what's the impact of these EU GDPR standard contractual clauses on the UK? Well, the old ones, as you'll undoubtedly be aware, is because we're a member state of the EU, when they were issued, they automatically related to the UK. These don't. And the ICO's position is that they are considering whether to adopt them. It's probably not likely that they'll be adopted in their entirety, because certainly some of the statements that are coming out of the ICO and DCMS is that there will be a UK version of standard contractual clauses that will be a lot more flexible and easy to use, So essentially what you could end up with, and I think is looking likely, is that there will be some standard contractual clauses that you will use if you are caught by EU GDPR to export personal data, for example, to America or India or wherever, and a different version if you're caught by UK GDPR and you're exporting to the same jurisdictions. So what you're potentially going to need to make sure that you've checked is what is the data, which version of GDPR are you caught by in relation to that data? Do you need two sets of standard contractual clauses? Which on the basis, it's not always that easy to get one set of standard contractual clauses signed off. Going to somebody who's not necessarily that familiar with GDPR and wanting them signed to two different versions, I think is going to be a challenge, shall we say. I think one thing that is for certain that's relevant both in relation to the standard contractual clauses and also in relation to the recommendations coming out of the European Data Protection Board is you need to know what your data flows are and your contractual arrangements. So moving on to the European Data Protection Board recommendations. The point of these recommendations is to help with the Schrems 2 analysis in terms of, well, how do you work out whether you can use these standard contractual clauses, and are there any other provisions that are going to cause a problem? So essentially, they are to be welcomed, I think, in terms of the new version, because it allows a more risk-based approach when doing the analysis. And if we move on to the next slide, I'll explain what that analysis is under the European Data Protection Board recommendations. One thing to bear in mind, sorry, and I did say I would mention this, is that they are deliberately called recommendations because they have, you should regard them as being something with more oomph than guidance. They're not law, but they have been signed off by each supervisory authority of the member states. And so the view of the European Data Protection Board is that they are more than guidance and that you should have a good reason for ignoring them if you choose to ignore them. So I think it's always useful to understand what the code of the Commission and the European Data Protection Board is. So guidance is sort of a lower level, then you've got recommendations and then you've got law. But it is worth bearing in mind that they are recommendations. So what you have to do to make sure that you can use the standard contractual clauses is, as I say, carry out an analysis as required by the Schrems 2 decision as to whether or not the law that you're talking about in terms of the place where the data is going is undermines the standard contractual clauses. So step 1, understand what your transfers are. 2, understand the basis on which you're sending the personal data. So for example, if you are going to send the personal data to Japan, it is likely that you will send it on the basis of adequacy, not on the basis of standard contractual clauses. And if you're sending it on the basis of adequacy, that's the end of it. You do not then have to do the assessment of the law of the country where you're sending the personal data to, because that's a done deal. And that is something that has been confirmed, as I say, in an event that I was attending by a rapporteur for the European Data Protection Board. Adequacy is the end of it. You do not then go through the rest of this process. So if you are using standard contractual clauses or binding corporate rules, you do have to go through the rest of the process. So you then assess the law of the country to see whether or not it undermines the standard contractual clauses. And that's a big part of these recommendations and very important, which I'll talk about in a minute. If the law of the country, and it's the law and practice. So one of the things that has become very clear is that it's not just statute, but other things can be taken into consideration in terms of understanding whether or not the SCCs are undermined. If you have got a problematic jurisdiction, is what they sometimes call it, then essentially you need to look at, do you need to put in place any supplementary measures? So do you need to put something else in place to essentially compensate for the fact that you've got a problem under the law of the country, the law and practice of the country that you're sending the personal data to? And if you do need to put in place those supplementary measures, and there are some examples in the recommendations, you've got to then put in place the, you've got to actually adopt them once you've worked out what they are, and then you need to keep everything under review. So moving on in terms of the step 3, which is the important part of this, I think steps 3 and 4 are the key things that the recommendations address. And the first is in terms of considering what the law and practice of the country mean in relation to the export. And there are 3 situations where practice is particularly relevant, which they've highlighted. And the first is, if on the face of it, the laws of the country that the personal data is going to are okay, but in practice, those laws are not given effect to, then the practice becomes relevant because the practice is undermining the law. Similarly, if you are sending personal data to a jurisdiction under EU GDPR and there are no laws relating to issues protecting the personal data, so for example relating to access by public authorities or rights of redress for the individuals who might be concerned by something that's happened to the personal data, then you need to look at practice because you've got no laws in terms of you have to look at other laws and the practice in this respect. And the third one is where there are problematic laws, so laws that look on the face of it to cause a problem in terms of undermining these standard contractual clauses, but practice changes how things are implemented, so they make the position better. So practice is relevant. And moving on to the next slide, as you'll see, a more risk-based approach. Sorry, if we can move on to the next slide after that, that'd be great. A risk-based approach can be taken, but it certainly should be documented. And the things that you can take into consideration in terms of making your analysis, looking at the laws, looking at the practice, are published statements, case laws, reports based on practical experience in terms of looking at things like chambers of commerce or trade associations, academic reports, NGOs, things like that. What they're very keen on is that they are publicly available sources of information which are objective rather than too subjective. So what they've said is sources should be relevant, objective, reliable, verifiable and publicly available to carry out this analysis. What you can't do, and whilst what's happened in relation to the person that is the importer or the sector relating to the importer is relevant, the fact that the importer says I've never had a problem, for example, with the NSA wanting to see my data before, that by itself isn't enough, so you need to fold it in. And certainly they're very keen on looking at a sectoral approach in terms of rather than just on the particular importer that you are using, but all of these things can be factored in. And if you are doing this analysis, I think I would definitely recommend that you go to the recommendations and have a look at the things that you can do. Now, one of the things I will say is that it's still complicated and I accept that it is complex, and certainly I think for SMEs, charities and things like that, it is going to be really difficult to do this. And one of the things that certainly was suggested by the European Data Protection Board is that if, for example, you have a Chamber of Commerce or an industry body and you fall within and they've done this analysis and you fall within that analysis, then you can potentially use it, but you do need to think about whether or not it properly applies to you, because this isn't just a one size fits all. You don't just go, oh, I'm in the financial services sector and they say it's fine. You've got to look at the particular data you're talking about and the particular sort of export and the use of the data to make sure that it applies in the particular circumstances. So those are the things that do need to be thought about. In terms of moving on to the next slide and having a look at step 4, if you have decided that you have got a problematic jurisdiction and practice isn't helping you, and you can't really hand on heart say that the risk analysis is essentially you can't actually come out and say that you can say that there isn't a risk, then essentially what you've got to have a look at are the supplementary measures in step 4. And it's useful because in Annex 2, it gives you an idea of what the supplementary measures are in broad terms, and I've put a list on the slide. So, for example, things like encryption, pseudonymization, etc. But also it gives you examples of use cases in terms of, so for example, if it's this sort of situation, so if you have got a cloud hosting agreement and it's all hosted offshore, but it's all encrypted, then you know, that is something that they see can work. Other things that are worth thinking about is, for example, if you are transferring to a lawyer or a doctor, that there are separate professional secrecy obligations which sit on top of the law, then that might be an additional measure. And equally, if you're potentially splitting the personal data. A couple of things to bear in mind, and the first one is that there is an acknowledgement that encryption degrades. And by that, what they mean is that the ability to process large amounts of data and the ability to essentially get around the encryption will change over time. So don't use old encryption, keep thinking about it and keep using it up to date. And also pseudonymization, what they've suggested on pseudonymization is that you might want to think about, you know, that might work in some situations, but you might want to combine it. And that is one of the points that they have made, is that quite often, to actually be an effective supplementary measure, you might need to combine some of these provisions. One of the supplementary measures that's in there is the fact that you could put additional contractual provisions around the transfer. They are very keen to point out that that of itself is not a supplementary measure that will fix a problem with the laws, because back to the point that Shrem's made in terms of a contract between the exporter and importer doesn't bind, for example, the NSA in the States. So moving on, just to sweep up a couple of things at the end. In terms of Privacy Shield, I mentioned in relation to Shrem's that Privacy Shield had gone. Politically, there's a lot of political will, moving on to the next slide, to get a new version of Privacy Shield, so whether we'll see Privacy Shield 2. I think the change in administration in the US obviously caused a bit of a sort of slowdown, but our understanding is that Biden is very keen to bolster alliances with the EU, and so that they're trying to push that ahead and get that done. And I think both parties are saying that it is taking time, but there is will on both sides to get it done. And I think the latest statements are around things like pretty much being 95% there. So we'll wait and see what comes out of that, but hopefully potentially there is an agreement on Privacy Shield too, because that'll make the transfers to America a lot easier. And finally, moving on in terms of to the UK approach to data export post-Brexit. As I mentioned earlier, there is a UK version of GDPR, and any transfers of personal data outside the UK have to be subject to either adequacy or safeguards. The government have said we can send it to the EEA still because they regard that as being fine. If it goes to the States, for example, then essentially there have to be safeguards put in place in the same way that data under EU GDPR do. Now, moving on to the next slide, just to flag a few things with you, is that whilst we have adopted, the UK has adopted the adequacy decisions made by the Commission, and we are now going to be making our own adequacy decisions, and they will not necessarily align with those of the Commission. So essentially what DCMS and the ICO are saying is that decisions will be made by DCMS rather than the ICO, and that essentially there will be a list of priority companies coming out soon. DCMS have said that the government plans to promote the free flow of personal data globally and across borders, including through ambitious new trade deals and through new data adequacy arrangements with fastest growing economies, whilst ensuring that people's data continues to be protected to a high standard. Not wishing to be cynical, but that sounds like it's quite trade-based rather than quality of data protection standards. So it'll be interesting to see what the priority countries list will look like soon. The other thing that has also been said, and it sort of feeds back into whether or not you can use the new standard contractual clauses for data protected by UK GDPR, is that we think that there will be a UK version of standard contractual clauses, and that the EU standard contractual clauses are not going to be adopted by the ICO. And again, we're expecting something to happen this summer in relation to that. So back to the point, you might need 2 sets of clauses. And very last thing is that also, moving on to the next slide, that there may well be, there are going to be UK binding corporate rules. And so again, watch this space. If you have existing binding corporate rules, then and there aren't many people that do have existing binding corporate rules because they're not easy to get hold of, sorry, to get through the process, then you should have gone back to the ICO before 1st January this year. So that's the end of the presentation. I am sorry that we've sort of not been able to address a lot of questions at the moment. If you have been able to leave your email address in the Q&A, then we can come back to you. Alternatively, if you want to contact me, then my contact details are on the slide showing the panelists, and we will circulate the slides and the recording of the presentation when it's all been sort of formatted and sorted out. Equally, in the Q&A, there's my LinkedIn details, so by all means feel free to contact me that way. So thank you very much for joining us today. I don't want to run over because I know that a lot of people squeeze this in their lunch hour, and so I'll say bye and thank you very much.